The U.S. Supreme Court is poised to strike a fatal blow to voting rights, and the consequences could be devastating. The impending demise of the Voting Rights Act's Section 2 is a stark reminder of the ongoing struggle for racial equality in America. But how did we get here? The Voting Rights Act, a landmark legislation from 1965, aimed to protect voters from racial gerrymandering, a tactic used to diminish black political influence. Section 2. The last remaining shield is now under threat. In the Louisiana v. Callais case, the Supreme Court seems ready to invalidate this crucial provision, completing a decade-long process of dismantling the act. Here's the backstory. Louisiana's post-2020 census redistricting sparked controversy. Despite a population one-third black, the state approved maps with only one majority black district, rejecting fairer alternatives. Voters fought back, and federal courts intervened, ordering Louisiana to create a second majority black district. But a group of non-African American voters sued, arguing that this remedy violated their rights under the 14th and 15th Amendments. They claim that addressing racial discrimination against black people is in itself discrimination against non-black individuals. And this is where it gets controversial. The Supreme Court seems inclined to agree, potentially marking the end of the Voting Rights Act. Chief Justice John Roberts has a history of weakening this act, notably in the 2013 Shelby County v. Holder case, where Section 5 was significantly weakened. This section required states with a history of racial discrimination in voting to seek federal approval for changes to voting laws, but the court ruled that racial animus had diminished, giving states more freedom to enact potentially discriminatory voting laws. The impact was immediate. States introduced new voting restrictions, and the gap in voter participation rates between black and white voters widened, particularly in districts previously under Section 5 scrutiny. Fast forward to the present, and the court is applying the same logic to Section 2, questioning its continued validity. Justices Kavanaugh and Alito argue that partisan gerrymandering, even if it has racial implications, is justified if that's the lawmaker's intention. This stance ignores a fundamental principle. Discriminatory impact, regardless of intent, constitutes illegal racial discrimination. Justice Ketanji Brown Jackson passionately defended this position, but her colleagues seemed unmoved. The case reveals the court's troubling trends, dismissing racial justice claims by minorities and twisting civil rights law to reinforce historical racial hierarchies. Louisiana's Attorney General, switching sides, argues that assuming black and white voters would vote differently is a racial stereotype, a claim that drew skepticism from Justice Kagan. Chief Justice Roberts has long opposed efforts to address racial discrimination, advocating for race-blind policies despite their real-world discriminatory effects. If the court rules for Louisiana, racial gerrymandering to diminish black voter power will be effectively legal, while using race to enhance black voter power will be illegal. The court's reasoning is flawed and disingenuous. By claiming that securing black Americans' voting rights violates the very amendments meant to protect them, the court is acting in bad faith. If the non-African American voters prevail, the decision will likely come in June, just before the 2026 midterms, potentially giving Republicans a significant advantage in the House. The fate of voting rights hangs in the balance, and the court's decision will shape American democracy for years to come. Will the Voting Rights Act survive, or will it be another casualty in the battle for racial equality? The answer lies in the hands of the Supreme Court, and the implications are far-reaching.